Chuck,
Yes.
the floor is yours. You should be able to share the screen. Let me know if you cannot do that.
Okay. Then I will start. My name is Chuck Black. I am a freelance writer. Before COVID, I was featured in publications like the Globe and Mail, the National Post, CBC, CTV, Global, a lot of American publications as well. But during COVID, I ran afoul of the censors and I was banned in a number of my old writing haunts. Since then, I've put together a Substack where I continue my writing, focused now on the Canadian political landscape, maybe the political medical landscape, and I try and keep busy. The presentation you are about to hear is an abridged version of something I wrote about in my Substack about 2 weeks ago. It's uh, it's about the concept of judicial notice and how the concept of judicial notice has essentially corrupted Canadian jurisprudence, completely messed it up. And with that said and done, I'm going to share the screen and show you a little bit more graphically what I mean. Here we go. Can everybody see this?
Yes, very, very well.
Ooh, okay. Uh, First off, what is Freedom Forum News? That's my primary channel to get my content out. That's something I set up about a year ago with 3 or 4 friends. Our primary content is 2 video productions that we do every weekend, one on Sunday, one on Monday. The first one critiques legacy and new media techniques and technologies. The second one is sort of an overview of the week's news, the most important news stories of the week. We're part of the fast-growing alternative new media ecosystem. We're not legacy. We're not 50% funded by the federal government. And because of that, we are allowed to come up with ideas that aren't generally accepted in the mainstream. And this is at chuckblack.substack.com. Uh, Here's what front page looked like about a week ago. Normally, I put up 4 or 5 different posts every week. Now, the thing I want to talk about tonight is my May 26, 2024 post on how the historic concept of judicial notice has been twisted by the Canadian courts. Now, this is something that goes back 100 years, 150 years, back to our common law roots. It is an exception to the fundamental Canadian legal rule that matters relevant to legal actions must be established through a formal proof, formal witnesses, and or independent evidence. And there were some very good reasons for this initially. It was allowed primarily in matters expected to be accepted without challenge by the courts. These are matters of facts. These are matters of legislation as described by government. These are things that neither the prosecutor in a court case nor the defense in a court case would ever potentially object to. And if you look at the bottom right, you see a 1995 book, The Law of Judicial Notice, that essentially is available these days. You can find it at the link in my article. You can buy it for $100 or so, and it coalesces all the common law on judicial notice into one easily acceptable textbook. This was published in 1995, and it remains to this day the most cited document on judicial notice. Uh, it was so heavily referenced when it first came out in 1995 that there was a Supreme Court case defining the terms and the functions of judicial notice. It was a very hotly contested court case. It made the news, and it essentially codified all the laws of judicial notice, and it served as the standard for all court cases moving forward. Now, the only problem with this book, well, there's an advantage to it. It saved time and court resources by eliminating the need for formal proofs of well-known facts. So that was a good thing. But over the last decade, one specific concept in the courts, as outlined in this book, has led to our current problem. And this concept in the courts now allow controversial political concepts such as climate change, systemic racism, and even things like fifth wave feminism to be entered into court documents without challenge. And the reason this happens is that any government document can be accepted into court records without challenge. Now, 30 years ago, when this book was written and the law was defined, the government published Hansard. The government published laws, rules, regulations, interpretations of laws. It did not publish policy papers. It certainly didn't publish controversial papers on things like climate change, systematic racism, or fifth wave feminism, but now it does. And government statements are now assumed to be without challenge in Canadian courts, no matter where they came from. the Government of Canada website, anything, just so long as there's a government statement supporting it, it can now be accepted into jurisprudence without challenge in Canadian courts. Now, since 2020, this is the bad part. Government pronouncements regarding science and medicine are now also assumed to be so obviously true and verifiable, they need not be questioned by the court. And if you go into the article, right now I'm giving you a high-level overview, but the article quotes jurisprudence. It's designed specifically to be something that can be reproduced by a law journal. I used to sell computer software to a big law firm, so I understand how they write. And this article I wrote is specifically designed not just to be understandable to you and I, but it's designed specifically to be understandable by the legal community. It's been vetted by a couple of lawyers. It's been vetted by a number of other people. And I'm pretty confident at this time that what I say and what I wrote about in this story is basically true. Since 2020, government pronouncements regarding science and medicine are assumed by the courts to be so obviously true and verifiable, they need not be questioned. And if you look at the Government of Canada website, you will find hundreds of position papers, primarily written by supporters of the current Liberal government, talking about things like fifth wave feminism, talking about things like 15-minute cities, talking about things like the COVID crisis and the pandemic of 2020 to 2022. The Canadian legal system now accepts those pronouncements, those papers, without challenge in Canadian courts under the concept of judicial notice. Now, here's where I'm coming from. The story was written with citations to primary source material. It was written in a format understandable to the legal community and to independent observers. I've left out a lot of the citations in this presentation, but in the primary document, those citations are there. They're verifiable independently, and they're being used in a number of upcoming court cases, particularly relating to COVID, and they hope that there are things we can do to bypass judicial notice, or at least object to it. And my job now is to tell everybody in the world that will listen how the Canadian legal community has bastardized itself over the last 10 or 15 or 20 years. My job is to get the story out to the legal community, to the activists, to the politicians, and to the people on this call. And for that, I need your help. There's my content. There's my contact information. There is a link to the concept of judicial notice. At this point, I'm happy to open the floor to questions. Thank you for your time.
So the first question is really what people should do when they go to the court and they try to defend their case. For example, they have been suspended because of mandates, and they believe this decision was wrong by the government. So how can they craft their defense so that they will not be easily removed even from consideration by just quoting a government statement that mandates are good for you? But
well, okay, continue.
Yeah, but instead, we could possibly use the same request for judicial notice to state some other facts which do not need to be proven, such as, for example, inconsistency of the government publications related to different levels of efficiency. Another fact, maybe transmission has been now proven that vaccines are not helping with transmission. So again, we can use this judicial notice potentially for our own benefit, just as the other party can use their judicial notice for their own benefit. So can you perhaps just explore these two opportunities or constraints for both of us, for both, for the other party and for us?
I'm going to start with a very obvious point. Judicial notice is only useful when the judge agrees with you. If the judge agrees with you, you can use the judicial notice. But the determination over whether or not judicial notice is appropriate is 100% up to the judge in the specific trial. Your only immediate option is to appeal the court case. Many of these court cases don't mention judicial notices at all. So you craft an appeal by saying, I appeal because some of the facts accepted under the judicial notice provisions are not facts as I understand them. They are facts that are often questioned in the scientific community or among social scientists or by everybody but the government. And when then you have grounds for an appeal. You don't have to say what the specific fact was. But you do have to say this fact was accepted under judicial notice provisions, even though nobody said it. And you can make an appeal that way. And that opens it up for all sorts of information on the specifics. You don't even have to show you are right or the government has to be right regarding things like COVID provisions and stuff like that. You have to show only that reasonable people will disagree. That's your first immediate choice. Now, I've also heard stories that the only asking for an appeal drives court cases out. It makes them longer. It makes them more costly. The government can afford to do this because the government can print money anytime it wants to. But the individual, you and I, we don't have the war chest to do appeal after appeal after appeal after appeal. So over time, our only real option is to pass a law. Questions of scientific fact, questions of sociology, anything outside of the reference of government documents for laws is not allowable under judicial notice. And I've spoke explicitly with members of with teams from legal groups responsible for appeals of a number of COVID lawsuits, and that seems to be the ultimate decision they feel is the best thing. And over the short term, they just got to raise more money and appeal till the government gives up. One day these things will get to the Supreme Court. I'm assuming Adam Skelly's trial, which comes up in October, should be the first one to get there. He's got a long and complex series of charges, but he's the furthest down the pipeline to the Supreme Court. So I think their legal team will bring that up first. Anyway, I hope that answers your question. There's one short-term solution.
That's definitely the beginning of a very important discussion. A note from one of attendees of this forum is that apparently judges have taken opposing positions on whether, for example, vaccines prevent transmission or not. Some of them use perhaps judicial notice to state that it is known that vaccines, in particular COVID vaccines, do not stop transmission. On the other hand, some other judges may state the government has published that vaccines stop transmission, so we will use the government position. How is it possible in Canadian system? Do you think it's actually possible that within the same Canadian system we have two opposite decisions to the same question?
I believe it's entirely possible. As I understand the jurisprudence, the law of judicial notice is entirely dependent on whether the judge accepts it. I would also argue that since 2015, the Liberal government has been passing along position papers to the judiciary, explaining to them the concept of the law of judicial notice and explaining to them where the position papers are that they need to reference in order to come down on the side of government. And the suggestion is that if the judiciary doesn't follow alongside of, doesn't follow down the government path, the government may not promote them.
That's a very important point you made. Now we will publish this video on YouTube. We will publicize it on Substack. Perhaps you can do it on your site. I'll do it on my site. But my main effort is to provide people with ideas on what they can do now with this knowledge at hand. Mm-hmm. How can they make use of this tool? Right. And one of the ideas which I've heard on YouTube, as I was looking for tutorial on judicial notice, they were saying a few scenarios where it could be used. For example, it can be used to find inconsistency from when the other party says, yesterday they said A, today they said the opposite of A. And this could be used as evidence that the party changes their mind, for example, mm-hmm. on the same subject. So it's one idea. I was thinking of some other evidence which does need to be proven. For example, delays in publication. I was thinking, what do you think from your personal perspective, is it kind of valuable scenarios or options for us to execute to look into the data even published by the government or by any other person or party for that matter, and try to find inconsistencies, for example, related to COVID narratives?
I would argue that inconsistencies don't matter. The jurisprudence is not designed to be consistent. It's designed to be confusing. It's designed to lead you on. It's designed never to give you a solid answer, and it's designed to sap your strength. The last time I came across this sort of changes to the law was in Hong Kong in the early 2000s when I spent some time there. I hung with a couple of old friends of mine, one who wrote for Reuters. and I saw what the Chinese government did to the jurisprudence in Hong Kong. They're intentionally making it complex. They're intentionally trying to confuse you.
Okay, we have a question from the audience.
Certainly. Hello, Andre.
Andre?
Hi, I'm Andre. I was just wondering if can parliamentary questions and answer be considered as judicial notice?
I haven't the foggiest. I would argue that judiciary notice has not explicitly referenced parliamentary conversations that I'm aware of.
So I guess it would be worth to attempt it and see what happens, I guess. Experiment and try it.
It would be worth it. I mean, no guts, no glory. The legislation does explicitly say publish.
Oh, okay. So published documentation. Okay.
Yeah.
Okay. Just on a similar vein of that, to bring things up, I noticed that Section 25 of the Evidence Act can also be useful for people, where it states copies of statutes, official gazettes, ordinance, regulations, proclamations, journals, other appointments to office, notices thereof, and other public documents perpetrating to be published by or under the authority of the Parliament of the United Kingdom or of the Imperial Government or by or under the authority of the government of any legislative body of any dominion, commonwealth, state, province, colony, territory, or possession within the Queen's dominions shall be admitted in evidence to prove the contents thereof. And so, from my understanding, when I read that in the Evidence Act, anything that has passed in Commonwealth countries can potentially be used as evidence in our courts. So let's say if there's a favorable position that passed in England that you want to bring in as case law, you can say, well, if they say, well, that's outside of Canada, you can say, well, according to Section 25 of the Evidence Act, this could potentially be used as evidence. Again, I'm no lawyer. I'm just saying this out loud.
The short answer is, yeah, the short answer is yes, you are probably correct, but it is all dependent on whether or not the judge accepts it. The judge gets to accept evidence willy-nilly in his court, as Canada's set up right now. Your only real option is to appeal the court ruling.
Right. And just further to that, there's a case that talks about that, where they say, under the public document exception of the hearsay rules, reports of the public officials are admissible for the truth of their content. And there's case law provided with that. I provided that information in the chat if you guys want to review that, because it's basically saying that anything that's said by a public official is considered to be truth. Just 1 second, I have that here. It says, reports of public officials are admissible for the truth of their content. So that's under paragraph 26.
Yes. I would say that's one of the antecedents that led to the 1995 ruling on that I've been speaking about.
Okay.
Very interesting.
Now
I have a question. I have a question related to what has been asked by the previous person. Published publications only. Does that include OPKs, like open period questions, ATIPs, access to information, for freedom of information, documents which have been released? Do you think this could be used as evidence which doesn't need to be proven?
I think it can be used as evidence for an appeal. I would argue that the only sure solution to this loophole in Canadian government law is passing a new law saying that the government cannot pronounce on questions of science. Government cannot pronounce on questions of sociology. And government statements cannot be accepted without question when there is reasonable doubt as to its validity.
Yeah, that seems like a good way to improve the democracy or democratic way or judicial system in Canada. I am not expert in the legal matters. It's very interesting to listen to different presentations from different people like yourself. But again, it would be nice to invite some legal folks, right? So some people who have been trained in this business to see what they think about it and what could be done, like formally done. Perhaps indeed the request could be submitted to some organization and make amendment to this act or whatever.
I sympathize with what you're saying, Dimitri, but I caution you that I haven't just been in Hong Kong and China in the early 2000s. I was in Russia in the late 1970s and the early 1980s. I'm older than I look. And the people around the table in both those countries at that time had very similar discussions to the discussions you and I are having today. And they always got hung up around the idea that maybe we should bring in knowledgeable experts. And I caution you, the law was designed explicitly for the everyman to fight against the experts using reason and evidence. The lawyers are trained to miss a lot of the things that you and I would notice immediately. So don't discount your ability to add useful content to this debate. Don't depend entirely on the experts.
That's a wonderful statement for the conclusion of this presentation. Again, everyone, it's up to you to make use of this knowledge, right? And perhaps we have another example of where ordinary Canadians may know better or can defend better themselves than some legal folks. And I'm talking now about Bill of Rights versus Charter of Rights, for example. So we have many wins in legal system where people were defending themselves using Bill of Rights, and we have plenty of losses when which for the cases which were crafted by professional legal folks who have been paid substantial amounts and they lost just because the Charter of Rights has the clause number 1, which essentially makes your rights conditional on some statements made eventually by the government itself. So this is a topic for another discussion. I'm not sure, Chuck, whether you were following in your journalistic endeavors Bill of Rights versus Charter of Rights, but that's, again, topic for another discussion.
I've done some work on it. If I could make one more suggestion, one of the people who came to me after my presentation for the Freedom Rising Group a week and a half ago, her name is Carrie Simpson, and she passed me along a number of documents provided by the PMO's office, by the federal government, to various justices around the country, talking to them about how policy doesn't just derive from laws, but it derives from policy papers relating to schooling, relating to LGBTQ issues, relating to policies that the federal government may have favored, but hasn't yet written legislation about. And it's reminding justices of their duty to accept the policy papers, not just the law, when dealing with their jurisprudence. Now, I just put Carrie Simpson's name and her email in the chat. I'm hoping that if you'd like to find out more, you give her a call and you ask her what she told me. I'm sure she'll say the same thing.
Excellent. So I'm not sure whether we'll make this part available to public, but for sure for our little group, it will be very interesting to follow up on that.
And that works for me. Carrie has a lot of things in her plate.